My name is Paul Howard. I am the Fulton County District Attorney, and I am here with the chief lawyer in this case, Clint Rucker, and also with Diane's mentor, Mr. Billy Corey. And first of all, we would like to say to Diane, we hope that you are watching, and we hope that you felt that we stood for you and we stood for the things that you represented. Secondly, we would very much like to thank the jury. I think most of the people who watched this case could see that the jurors worked extremely hard. They took notes, they were very attentive, and they did something today that might not happen in the normal case. At one point, they said they couldn't reach a verdict. The judge charged them with the Allen charge, and the jury had enough ambition and reasonableness about itself to go back, and they returned the verdict. And we believe that the verdict is one that spoke the truth. I want to congratulate this trial team. I've been district attorney here since 1996, and we've had many what would be termed as high-profile cases. But Clint, I cannot remember a case that we have spent so much time trying to put the case together, so many weekends and so many nights until 2 o'clock in the morning. And so I really want to congratulate our team of lawyers and investigators who really did an outstanding job. I also would like to say a word about our criminal justice system here in Fulton County. And I know it's, people sometimes scoff at the idea of what might be seen as a good criminal justice system. But I truly believe that this trial and the verdict that was returned is not one that you might see in other parts of the country. And for myself, I'm very pleased with our Fulton County criminal justice system, and I believe that the people of our county should be equally proud of what they have seen over the last month or so, and today with the verdict from the jury. I'm going to ask Mr. Corey, if he would, to say a few words on behalf of Diane and his company, and then we'll hear from Clint Rucker. Mr. Corey.
I can say that I concur with District Attorney Paul Howard, Clint, District Attorney, Assistant District Attorney Clint Rucker. I can't improve over what he just said. I concur with the District Attorney statements here, and he has a brilliant staff, and the state of Georgia should be proud of our DA staff, our judge, and our jury. And may Diane rest in peace. They stood up for Diane today. Thank you.
Let me have y'all come over. She's down this side. My name is Clint Rucker, and I'm the Executive Assistant District Attorney here in the Fulton County District Attorney's Office. And I'd like to say, first and foremost, thank you to our jurors. They worked hard. They were here every day. They were diligent. We could watch them in court taking notes and paying attention very carefully to the evidence that was presented in this case. And I believe that today, with their verdict, they have spoken the truth and given some justice to the death of Landon Diane McIver. Secondly, I'd like to thank my team, who are all standing here around me. I don't do this by myself. I don't get all of the accolades. I'd like to share it with them because they have worked extremely hard and have been very, very dedicated to the outcome that we see here in this case. And thirdly, I'd like to thank the district attorney himself, who provided a great deal of leadership. He also provided the resources by which we were able to carry out the prosecution of this case. And so I'm very pleased today with the verdict that the jurors have returned. And I think it speaks volume for the progressive nature that is what I think is the community that makes up all of Fulton County.
And we'll take whatever questions you guys might have.
What did you hear from the jurors today? What did they say?
What they said first and foremost is that they had a real plan about how they went about their deliberations. They communicated well with each other, and they expressed to me the fact that they were happy that the judge asked them to go back and finish their work. And so I was satisfied with what they told me, which was that they were very, very confident in their verdict, and almost to a person, they all remained behind to speak with us.
Did they mention what they were deadlocked over?
They didn't.
This was a circumstantial case, Clint. What was it that was pivotal for them that they zeroed in on?
Well, you know, what they expressed to me was that the issue of intent provided some challenges for them, and it was because of the language in the charge. What they expressed to me is that the charge itself was a little confusing for them, a little hard to understand. It's written in legalese, and so it took them a while to kind of dissect the actual language of the charge. And to me, that is what I took that they spent the most amount of time.
Clint, early on, there was an assumption that this was an accident. And as APD began investigating, as your office began investigating, was there a moment during that early part of the investigation, that aha moment, where you went, I don't know that this is an accident?
Well, I think it all came together incrementally. You know, certainly the forensic evidence I thought was pivotal, that being that the handgun that was used in this case did not malfunction, was working in perfectly good condition, and required 12¼ pounds of pressure to be exacted on the trigger in order to make it fire. I think that was in direct contradiction to what the defendant in this case had been expressing, not only to the police but also to others. And I think that perhaps was step one.
When it comes to sentencing, I'm not asking for an exact number, but what's going to go into the process of coming up with what you're going to recommend?
Well, it's a mandatory sentence. It's a mandatory life sentence, and so there's not much mystery about it. The only question will be is what the judge might add to it, but at minimum, he'll receive a life sentence, a non-parolable life sentence. And one of the other things we like to say with respect to the evidence, you know, one of the things that really led us to start to understand that this was not an accident is the employees from Emory University. And we really have to thank the nurses, the doctors, and the staff members at Emory University because once we started to talk with them, and first of all, what they described to us was someone who was not grieving over the death of his wife. Then, when they started to reveal to us the different versions of the facts, certainly we started asking ourselves, well, why is it that someone who was telling the truth would need to come up with several different versions of what happened? So once we heard the people from Emory, and as Clint said, with some of the other stuff involved with the gun, as prosecutors, we hear this all of the time. We hear this term all the time, the gun went off. You know, some people say the gun went off and I shot him 8 times in the back. So we hear that a lot. And so when we heard it, it makes you suspicious. But then we started to see some of the other evidence, which clearly said to us this was not an accident.
Have you thought about, I got here late. Did you comment earlier about the difference between the fact they acquitted him on malice but convicted him of essentially aggravated assault? There's a...
No.
Do you see a conflict there at all, or no?
No. I think that the murder charge, as Clint mentioned, this whole understanding intent and then understanding malice aforethought, sometimes it's very difficult for people. But maybe it's not so difficult to understand if there's an aggravated assault, which there clearly was with the shooting. When a death occurs as a result of that, it's not so difficult to understand that that could be felony murder.
Clint, were you getting nervous when the first question from the jurors came a few days ago about acquittal and all, but the charge? Were you thinking?
No, but ironically, it seemed like everyone around me was extremely nervous about it, and it seems like I spent a lot of my time trying to get folks to calm down because I've been doing this work long enough to know that it's very difficult to have a crystal ball and understand what's going on in the back with the jurors, and sometimes questions may come just as a matter of course, and so reading so much into that question when they had only been deliberating a very short period of time. I wasn't concerned about it, and I expressed that to many people around me.
Sir, do you think going back down to the car was pivotal in their decision?
I do. I do. I think providing them the opportunity to be able to actually sit in the vehicle, to see the trajectory rod through the seat, to understand where the gun would have had to have been when it was fired was extremely important. And perhaps more so, when you put it in context with his statements, it's where the gun could not have been. I think that proved to be real pivotal for a lot of people.
Did they tell you that when you talked to the jury?
No, it's my opinion.
Right.
I actually wanted to ask Mr. Corey a question. At what point did you and your people who work with you sort of figure the story was not kosher in Texas?
Could we have Mr. Corey,
Can you come up here, Mr.
I think Clint just answered that question. A 38 don't go off by itself. It takes 12 pounds of pressure. I believe that answered your question, didn't it?
Sir, you said
There were a lot of people who were thinking this early on that this was an accident, but you were one of those people very close to Diane. Was there just something that you knew, that something just didn't smell right about this whole story?
It took me maybe a day or two for it to kind of sink in, because we were all Diane's family. We're Diane's family. Then we realized it was not an accident. We didn't think it was an accident, and the jury confirmed that today.
Sir, you said you hope this verdict brought Diane justice. What does that mean for you and for people who consider themselves her family?
It means just what you just said. It means it brought justice for Diane through these brilliant prosecutors here.
At what time did the prosecution team become aware that Diane's coworkers who had interacted with Tex that week?
You'd have to ask the prosecutors there.
I mean, what time did y'all sort of connect and figure, realize that there were a lot of people who had doubts about Tex's story?
We cooperated with the prosecutors when they realized that it wasn't an accident.
Clint, how important was Danny Jo Carter's courage in withstanding pressure and to stay strong in what she believed was her story?
It was tremendously important. The fact that her recollections of the events of that night remained consistent throughout. The fact that she was willing to cooperate with us and meet with us on occasions where she actually walked us through the events of that night. It kind of set a foundation for us in terms of how we were able to piece together what actually happened, not only that night, but the weekend prior, and in fact, years prior, because what Danny Jo Carter did was give us some foundational information regarding the relationship. And so she was perhaps the MVP.
Let me, and I also want to mention, because, when the case started, a lot of people had some not nice things to say about Danny Jo Carter, but I think there's one thing that they missed. For most of us, if we had been sitting in a truck and somebody fired a gun in the back seat, we would have been getting out of the truck. And most people would have gotten out of that truck real fast. But what they forget was what Danny Jo Carter was attempting to do was to save her friend, her best friend. Not many people would have been able to drive that vehicle to the hospital. And she did it because she was trying to save a friend. And so for ourselves, we really thank Danny Jo, because if it had not been for her, we would not have gotten to this point. Thank you, Danny Jo.
Mr. Rucker, during your impassioned closing argument, one of the questions you asked the jury is, who will stand for Diane McIver? What do you think the verdict today said about how that question was?
Well, I think in a resounding voice, the jurors have said, we will. We will.
Mr. Corey, can I just ask you, you said you were like family to Diane. Arguably nobody knew Diane better than you, and people who worked with her. Why was it so important for you to stand by throughout this case and make sure she got the justice she deserved?
Just like, because she was family. That's the reason, that was the reason it was important.
And what kind of person was she to you throughout all the years she worked for you?
What kind of person was she? She was brilliant, she was beautiful, she was shrewd, she was kind. I guess that's about it.
Mr. Rucker, I'm sorry, you explained it a little bit, but, you know, as Bill was asking about the difference between the malice murder and the felony murder and what sort of the verdict told you, can you just explain for those folks who will be hearing the difference between these, sort of, what is the difference and what them finding felony murder sort of mean of what
Right, right. Well, the finding of felony murder is the defendant had the intent to shoot Diane McIver by pulling the trigger on the gun, and as a result, it was a direct cause of her death. That, in essence, in Georgia, is felony murder. Malice murder, which the defendant was charged with in count 1, requires some different elements. It requires what we in Georgia call malice aforethought, which is a deliberate and intentional act that can be shown either expressly or through other circumstances. And so with the juror's verdict today, I believe that they have expressed to us that they unanimously have concluded that the defendant intended to shoot his wife, thereby causing her death.
And just circling back, when did y'all sort of first find out that there was widespread belief among Diane's colleagues, people who knew her well, that this was not an accident?
Pretty early on. We started investigating this case fully in January of 2017, and in short order, we began to reach out to the employees there at U.S. Enterprises, the Corey Company, to schedule interviews, and I think it was during those first weeks in January where we began to see that everything that the defendant was expressing publicly may not have been the case.